Cool.
Certainly.
So for those of you who may not know me, my name is Becca Boston. I'm with NAMI Pierce County, the local affiliate for National Alliance on Mental Illness. It's the largest grassroots mental health organization with over 700 affiliates across the United States. Here at NAMI Pierce County, we provide free support groups, educational programs, presentations, and advocacy for individuals living with mental health conditions, as well as families and loved ones affected by mental illness. This event was inspired by a need we heard from our community, specifically our family support group, where many expressed a desire to better understand legal options available when navigating complex mental health situations, particularly Joel's Law here in Washington. So today we're honored to be partnering with Kantor and Kantor to bring you this important and timely presentation called When Mental Health Care Isn't Enough, Understanding Legal Options. We ask that you please remain on mute and hold your questions or feel free to add them in the chat during the presentation. To note that this episode or this presentation will be recorded and there will be a dedicated time at the end to address any questions you may have. Without further ado, please join me in welcoming Andrew Kantor, a partner at Kantor and Kantor LLP and a trusted ally for families navigating disability benefits. Andrew understands just how overwhelming the process can be when a loved one is struggling with mental health challenges. He works alongside families across the country to help them make sure sense of legal rights, cut through insurance red tape, and secure the support they deserve. With a deep understanding of both the legal landscape and the human side of work, Andrew is here today to help you feel more informed, empowered, and supported. So without further ado, I'm going to hand it over to you, Andrew.
It's a really nice intro. Thank you very much. Thank you, everyone, for taking your time to be here to listen to me. I really appreciate it. I know your time is valuable, so I'll try and get as much in as I can. One thing I want to say right off the bat, if for any reason you don't get your question answered here, or I think more commonly, if you have a question that you don't feel comfortable answering in front of a group of people, we're going to give my email address in the back. It's actually my intake team, and it's much better to email them because they keep me organized because I miss things. So our intake team's email is going to be on the back, and you can email anybody, anything at any time. We don't charge for things like that. But if you have any questions that come up that we don't get answered, please feel free to email us at the end. And so this presentation really, my specialty is really about disability benefits. This presentation is really more about disability benefits and Joel's Law. So it's kind of a family overview of ways that families can struggle with mental health issues and mental health issues of their family members. Let's make sure I can move this to it. A little bit about me. I'll talk to you about my legal background next. I'm actually neither of the Kantors in Kantor and Kantor, at least not formally. Those are my parents, Glenn and Lisa. I mention that because one of the reasons I went into this area of law is to follow my mother's footsteps, and what she's been doing for the past 20 years basically is fighting wrongful health insurance denials. Basically, if you need health insurance or need health treatment and the insurance company denies it, she fights it. One of her specialties that she fell into a long time ago and just recently stopped doing because she's going to start retiring and being a full-time grandmother, is getting eating disorder coverage for young children, a lot of girls, but also boys as well, who couldn't get residential care because they technically weren't sick enough. So I got to kind of watch my mother do this as I grow up as a career, and it really always stuck with me. And the amount of basically help she gave people, the ability to really help them when they really needed it, and how badly health insurance and insurance companies treated people. My two brothers decided the last thing they would ever do is become lawyers after watching my parents, and I decided the opposite, that I wanted to do what they do. And so what I got into was still suing insurance companies, but disability insurance companies. I do a lot of other things, but the thing I do most is sue disability insurance companies for not paying disability claims. And a lot of those claims are for people who are disabled from mental health issues. And for anyone not disabled from mental health issues, and are disabled from physical issues, they also end up with mental health issues. So almost every single one of my clients has mental health issues, either severe enough to disable them or severe enough to impact their lives. And so one thing I've been kind of blessed with is to get a front row kind of view to how people operate, how they fight through these things, and what they have to do to survive in a way in a system like this. And I also really like the opportunity to speak to NAMI specifically. NAMI's actually already given up my firm a lot. We're one of the first firms who's going to be involved in the LA chapter stigma-free program, which is something we do for which we're going to do for our employees to support their mental health. We're actually the first law firm they have to do it. That's like the biggest badge of honor that I wear right now. I'm very proud of that. So this means a lot to me, and I'm really glad I get to be here in chat with all of you. So again, my specialty is fighting with insurance companies who don't pay short-term and long-term disability claims, and I'll talk a little bit about that in a little bit. I'm not an SSDI lawyer, which is Social Security disability, but I play one on TV. I don't actually play one on TV, but the overlap is so significant that I have enough knowledge to answer as many Social Security questions as I possibly can. And if you have Social Security questions I cannot answer, I will do my best to find the answer or to refer you to someone smarter than I am. I also talk a little bit about workers' comp. I'm not a workers' comp lawyer, and I couldn't play one on TV. I don't know very much about the workers' comp system to the extent I've been exposed to it. It's very complicated, very state specific, and you need a workers' comp lawyer. I'll talk about that in a little bit, but workers' comp comes into play if your workplace actually causes you injury from either an hostile work environment or any other emotional impact from your actual job. Doesn't have to be just your employees. If you're a first responder and you have emotional trauma from being a first responder, that certainly could qualify you for workers' comp. I'm a California lawyer. I'm also barred in Washington, D.C. I'm a month or two from being barred in Washington State. My application's in. I'm just waiting for them to approve it. I'm very excited about that. I'd say I practice and I've definitely practiced in California the most, but Washington is a close second. And I hope to actually move there somewhere one day near a lake with lots of trees. I really like Washington. So, with that, and also, my Joel's Law experience, I'll be totally honest with you, I don't deal a lot with Joel's Law myself. I educated myself as much as I could for this presentation. I learned a lot about it, and I'll definitely be able to give you a basic primer, and we'll walk through some questions and how that process works, and how the law how you can utilize it. So first, I'm going to talk about, before we get into Joel's Law, just talk about disability benefits. Basically, the version of disability that I'm talking about is, in the simplest terms, being unable to work due to mental health issues or any other issues, despite reasonable accommodations. So regardless of any accommodation any employer could give you, if you still can't do your job, that means you qualify as disabled. There are really four main sources of disability benefits. The first one is what I'll talk about, Social Security disability. That's by far the most common. You pay for it through your taxes. So if you've worked 4 years or more, usually you qualify for at least partial benefits. And if you've worked 8 years or more, you qualify for full benefits. That's a very simplistic explanation. It links to your taxes, and some jobs don't even qualify, but most people qualify for Social Security disability if they become disabled. The next source is private short-term and long-term disability. So that's through an insurance company. 90% of people get it through their job. So it's a benefit they offer just like health insurance, life insurance, or anything else. If you're not sure if you have it, you can ask your employer and they will tell you, or you can look at your pay stubs and they'll list it. I'll talk more about this in a bit, but short-term usually lasts 6 months and long-term disability picks up after the 6 months. PFML is something that's special to Washington. It acts as kind of a state disability program. I believe it gives you about up to 26 weeks if you're unable to work. It basically overlaps and with Social Security disability. You can file it through the state website. The fourth source is, as I mentioned a little bit earlier, workers' compensation. That only applies if you have, if your mental health issues are for some reason related to either your workplace or doing work. So I'll talk about Social Security disability first because it's the most common. You are eligible with Social Security when you expect to be disabled for at least a year. You don't have to be disabled for a year before you apply, but the technical rules are you have to expect to be out for at least a year. You have to have worked in a job covered by SSDI taxes. The big exception is government employees. Various government employees will not pay into the system and they'll pay into other systems. So pay attention to that if you're not sure. You also have to meet the Social Security definition of disability, which in the simplest terms is the inability to work in any significant capacity. The technical term means you cannot do any work which would earn you more than $620 per month. That is in my opinion, something of an arbitrary standard, and it varies based on what your capabilities are. If you only earn $3,000 a month to begin with, it's probably easier for you to argue you can't earn $1,620 a month if you're impaired. If you earn $20,000 a month, it's a lot harder to argue that you can't earn 1620, but of course that is only an issue based on your earnings. So the benefits you can get for Social Security disability, you can get a maximum right now of $4,000 per month until Social Security retirement age if you qualify. And you can get an extra 50% on top of that, so an extra $2,009 if you have any dependents under the age of 18 or that are over 18 but still living with you basically before they start college. So 18 in a few months basically. Um, Starting the claim process is very easy. Thankfully, it's still very easy. That hasn't changed. You go online to, I think it's ssa.online.gov, but you can Google how do I apply for Social Security disability, and it takes you right to the website. You can click on the link, and basically, you just put your basic information in. That part is really easy. Everything that comes after that is not quite as easy. So what happens after that is you'll enter a pretty long process where they'll request your medical records. They'll send you a bunch of forms to fill out. They may have you evaluated by someone. If you're disabled for mental health issues, they'll usually have you evaluated by a mental health evaluator, and then give an assessment based on whether they think you qualify under the standard. So the bad news about Social Security, if there wasn't enough already, is that it's unfortunately really difficult to get approved. Something like 85+% of people are denied at the claim stage. So just because you're denied the claim stage, don't give up. You should still appeal. The appeal process takes several years. It took at least an average of 2 years a year ago. They have not come out with the new numbers of how long it's taking now, but the thought is with the new administration, it's not taking less time. It's probably taking more given the budget cuts in the Social Security Administration. If you are denied, the best thing to do is to talk to a Social Security disability attorney. Their fees are actually capped by statute, so they can only take a percentage of your back benefits and only up to a certain amount. And it's extremely hard to get a Social Security appeal approved without a Social Security lawyer. So I strongly recommend talking to one if you have a Social Security claim and your claim is denied. One upside is that there's an age weight basically where the older you are, the more likely you are to get your claim approved. Because Social Security, one thing they'll assess is how easy it is to retrain you to do a different job. And the older you are, the less retrainable they'll assume you to be. Whether or not that's fair or not, it is what it is, but that's what the Social Security Administration says. Another thing I came across recently, there is an alleged new Social Security Administration proposal that's being passed around to change the way that the Social Security Administration assesses disability. Long story short, it is expected to make it even harder to get approved and to cut rates by 20% and allegedly make the mental health requirements more stringent so that you have to basically show a more severe showing of mental health limitations before you can qualify for Social Security. This is confirmed to be a proposal. There is no confirmation of how close it is to getting anywhere. Allegedly, one Social Security lawyer I talked to said they've been talking about something like this for 2 years now. So there's no reason to think it's going to happen soon, but it's out there. So that's Social Security. Short-term and long-term disability, again, is something you usually get through your employer. You can also buy it through a broker if you want to. If you don't have coverage, you can just ask your employer. One thing to pay attention to is that short-term and long-term disability are usually subject to pre-existing condition limitations. So unlike health insurance, which no longer has them, if you have any kind of mental health issue and then get coverage and then file a claim within a year, if you got treatment leading up to that coverage date, they'll probably deny your claim. So what this means is if you're considering filing a claim when you just got a job under this coverage, talk to a long-term disability lawyer first, or wait that year or two before you file the claim, because then you'll be exempt from that limitation. So the way Social Security, short-term and long-term disability works, so short-term disability usually lasts about 6 months, while long-term disability usually lasts to your Social Security retirement age. Long-term disability will usually give you about 70%, 60 to 70% of your income as the benefit amount. It's also reduced by other benefits. So if you get Social Security or PFMLA, your benefits will be reduced by that amount. There is almost always a 2-year transition in there. So for the first 2 years, you get benefits if you can't do your own job. And after that, you only get benefits if you also can't do an alternate occupation. So basically, you have to show that you're unable to do any job in the economy. It's a harder standard to meet. Um, an even bigger problem when you have mental health related disabilities is there are mental health limitations in long-term disability policies. So if you know you have long-term disability coverage, I implore you to look at the policy and check for one of these. There is probably a limitation in there which only pays you 2 years of benefits if you are disabled from a mental health limitation. This is a really bad thing, frankly. I wish I could say it better. It's a really bad thing we've been trying to fight for a long time. The only way to actually fight the existence of these limitations is to have states change their laws. Vermont is the only state in the nation right now which bans mental health limitations. A lot of employers for professional organizations will not have mental health limitations in their policy, but they'll pay extra for it. So if your employer is really good, you can potentially ask them about it and see what kind of coverage they offer. If you have long-term disability or this coverage and you know this limitation is in there, take a close look at it. There are a few ways that they can vary. Some of them actually have carve-outs. So while they'll limit your benefits for depression, anxiety, and a myriad of other things, they may not limit your benefits if you're disabled from schizophrenia or bipolar disorder. One insurance company actually has a secret carve-out where they don't think bipolar disorder is a mental health limitation, even though they don't say that in the policy. New York Life for anyone who has it. Ironically, their lack of knowledge about it, they say it's an organic brain disease, so they don't consider it mental health. It's like the one time they decide to be progressive about something, it's in that direction. There's other limitations which are overly broad in a scary way, where anything included in the DSM-5 counts as a mental health issue, and thus there's only 2 years of benefits. Alzheimer's is in the DSM-5. Mild cognitive impairment is in the DSM-5. So those are actually way more broad and can get you for a lot of other things. So the reality is, if you know that this limitation is in there and you're considering filing a claim, again, I would talk to a long-term disability lawyer, see if they know any way around it or any way you can contest it. But the most likely outcome is be prepared to only get 2 years of benefits. It's unfortunate, but that's the reality. But 2 years of benefits can be a lot, and especially for those who hope to get back to work within 2 years and heal, like that. Maybe 2 years is enough. For a lot of people, it's a lot. It ends up being a lot of money. So if you're going to go through the claim process, there's a few steps you'll go through. One is they'll ask you for a claimant statement, so they'll basically just have you fill out some forms explaining why you're disabled and what is disabling you. You'll need support from your physicians. They'll ask for a form from your doctors, and they'll have to fill out why you're disabled, what your treatment history has been. You'll also have to submit medical records. The medical records are usually directly from your provider. Now, with psychiatric and therapy records, many providers do not take traditional records or won't share them. So they won't share their records. It usually happens with therapists. What you can do instead is ask your therapist or psychiatrist for a summary treatment letter so that they can omit any of the any sensitive information while including everything substantive that they need to support the claim. Insurance companies are usually okay with this. During the claim process, you may also be asked to see an independent doctor to be evaluated. They don't do it as often as they do with Social Security for mental health claims. They usually prefer using what we call paper providers, where they just review your records and find reasons to poke holes in it. But you can also be evaluated in person. So there's a few practical realities for long-term disability. Most long-term disability is governed by a federal law called ERISA. ERISA is evil. It's one of the worst laws out there. It's what we specialize in, so we deal with it all the time. I say it is evil for one primary reason. It stops you from suing an insurance company for bad faith. And what this means is, if an insurance company were to deny your claim, let's say they owe you $100. Under normal circumstances, you could sue them for $100 and $1,000 for all the bad things they've done. So insurance companies, big evil corporation, they think, oh, well, I really shouldn't treat people poorly. I might get sued for $1,000 instead of just paying the $100 I have. Thus, this deters bad conduct from insurance companies. You might be surprised to hear that ERISA, which governs most health insurance as well, precludes you from those damages. So if they treat you poorly and deny you $100 worth of benefits, all you can get from them is the $100 of benefits back, and maybe some attorney's fees if a lawyer like me goes all the way to trial and wins. What my father always likes to equate this to is if the laws for bank robbery were, if you got caught robbing a bank, you had to give the money back. and that was the only punishment, how many more bank robbers would we have? Like, people would just give it a shot, because the worst thing that happens is you give the money back if you're caught. And that's pretty much how, and one of the reasons why health insurance and the insurance system in America is so awful is that this federal law basically made it so insurance companies don't have any actual punishment for treating people poorly. And so couple this with disability claims, where people are going through either physical or mental health related disabilities, and insurance companies treat them horribly. It really combines for a really awful situation for extraordinarily vulnerable people. I'm sorry to get riled up. It just, frustrates me to this day that the Supreme Court took this pension law from the 70s and just destroyed it and made it one of the worst laws out there. If you have a government or religious employers, if you work for a church organization or a county, anything that falls into those two categories, your claim is not governed by ERISA. It's governed by state law. Washington has some pretty good state law when it comes to insurance bad faith. It's just like California. They like to hold insurance companies accountable, so that's a great thing. The process is adversarial, just like health insurance. If any of you have been through any kind of health insurance process trying to fight with an insurance company to pay for a treatment that they don't want to pay for, that's basically the long-term disability process, with the one question of, are you able to work? They do not want to pay the claims. They will push back every chance they can. And it's just, frankly, unless you have a lot of support, it's often a very adversarial process. So I want to tell you what common reasons why mental health claims, either Social Security claims or long-term disability claims, are often denied, so you could potentially preempt them. So one very common reason is no psychiatric treatment or no psychiatric medications. Now, I want to distinguish these a little bit. So I've seen many clients who have psychiatrists, and for whatever reason, their psychiatrists take them off of psychiatric medication or order them not to take it, or for whatever, or physical medicine doctors order them off of it. That is a very different thing than not seeing a psychiatrist. Basically, from the insurance company's perspective, if you are impaired enough not to be able to work, you are also impaired enough to need psychiatric treatment of some kind or another. Now, if your psychiatrist says, I don't believe that psychiatric medication is the best thing for you, that shouldn't be an argument the insurance company should be able to use. You're getting the treatment, the psychiatrist is ordering it, you're complying with that treatment. But it's very important to at least see a psychiatrist. I know a lot of people tell me they can't afford it. A lot of people, they tell me they can't find someone they trust. I understand all of those things. And I wish I had an easy answer other than do your absolute best, because without trying to see a psychiatrist, these claims will be denied. No referrals to higher level of care. So this one I see a lot, and it makes people really anxious. And I understand. Basically, a lot of people can be impaired enough to not be able to work without needing outpatient or inpatient treatment. That's a very common thing. However, what insurance companies like to see is at least a discussion of it. At least talking to your psychiatrist or therapist about the possibility, either them bringing it up or you bringing it up, and having a plan as to when things get bad. What are the steps that are going to happen before you go into inpatient or outpatient treatment and escalate your level of care. I fully understand how big of a step that can be, and how wide of a gap there is between I'm not able to work and I need that level of care. I also fully understand how inaccessible that level of care can be when you need it. I also know that when people are in these positions and impaired, they're often in the worst position to convince themselves to attend these levels of treatment, as if you have family members who are going through that. So not having higher levels of care is definitely not an automatic denial. It is not something you should be afraid of. But if you don't plan to do it, or it's not in your future, I think one thing that can definitely boost your claim or preempt that denial is talking to your psychiatrist about it, and them agreeing it's not necessary, but when discussing when it would become necessary. Usually, frankly, that involves if there's no suicidal ideations, and suicidal ideations or something like that, or other examples of you potentially being a danger to yourself. Like, that would be an example of an agreed upon trigger for escalation. So infrequent treatment is another one. Regardless whether you're getting psychiatric or care from a therapist, you want to make sure you're seeing them regularly. If you're seeing your therapist once a week and only seeing your psychiatrist every few months, that's fine. You don't need to be seeing your psychiatrist once a week. I understand how medication management works. If you have a psychiatrist who's willing to communicate via email, that's really great. So you can communicate about your medication changes and medication struggles. Because often people, you deal with so much in between 2 or 3 months between seeing your psychiatrist. You have to report it all at once, and then sometimes it's not as easy as if you reported it when it's happening. Um, so you also want to make sure you're at least seeing your therapist. I'd say at least once every 2 weeks. Again, it's the argument where if you're impaired enough to not be able to work, then you're impaired enough to need that kind of level of treatment. I do also understand that that's not always accessible. Other times, your doctor doesn't recommend it. Your therapist or psychiatrist will say you don't need treatment this often, but here's why you can't work. Um, if you're not getting treatment as frequently as I think you should, one great thing is to get from your psychiatrist or therapist an explanation of why you're only treating every 3 weeks, every 4 weeks, why you only need that level of care. If the answer is you can't afford anything else, say that. Your therapist should say that, because that'll preempt them, the insurance company, saying, well, if it was more serious, you'd be treating more frequently. You can just respond, if I had more money to treat, I would. So it kind of preempts that potential argument. So another thing that can cause trouble is inconsistent activity, and I use this very clinical term. Basically, it's what insurance companies do when they either surveil you or go on social media, and try to take little snippets of your activity out of context, and try to allege that, well, if you can go to a Dodger game, or sorry, go to a Mariner game. Excuse me, go Mariners right now. They've earned it. If you go to a Mariner game, how come you can go to a baseball game for for 3 hours, but you can't work? How come you're able to walk but not work? You showed the social media you were traveling. Why can you travel but not work? There's a few things to consider with all of this. The first thing is the only activity that's harmful is actually inconsistent activity. So if you're telling them, hey, I'm not able to work because of my depression, but I'm still able to go to baseball games because that doesn't impact my depression and that actually helps my treatment, that should be okay. Like, the insurance company shouldn't be allowed to attack you about that. If you say you have anxiety in crowds and you tell them you're going to a Dodger game or a Mariner game and they catch you at a Mariner game, that could cause problems, because if your crowd aversion makes it so you can't work, you shouldn't be able to go to a Mariner game. Same thing with physical activity. A lot of times people are impaired with mental health issues and are encouraged to stay active, keep doing things if you can. And it's often a massive struggle to even get out of the house. So, someone might go to the house and force themselves to go grocery shopping, and the insurance company will say, well, you were grocery shopping. How come you can grocery shop but not work? And you say, hey, this was the one time the past 3 weeks I was able to go out. Or you say, I've always told you I can grocery shop because that's the one event I can do each week. My doctor tells me to do it. I talked to my therapist about doing it. And here's the list of things I wasn't able to do that week. So just make sure what you are doing, you're honest with them about. The biggest thing they can do is catch you being dishonest about something. So, if you're going to Mariner games and they catch you going before you tell them about it, it doesn't really matter if you have an explanation, because what they're going to assume is you're hiding things from them, both the Social Security Administration and long-term disability. So it's always, people ask me, wait, should I disclose this? This might look bad. Even if it does look somewhat bad, it's better to disclose it, give an honest and straightforward explanation. Because if they come back and eventually deny, you can later say, hey, I didn't think this conflicted with my disability claim. I was honest with you about it from the get-go. If they catch it, they basically have you in a corner admitting that this thing was contrary to your disability claim. So also be very mindful of social media. My God, social media is the bane of a disability lawyer's existence sometimes. I mean, every rational human knows social media is not the actual representation of you. It's your best self, or it's the self you want to put on the internet. People often put their best moment of the month online, like the one time they go out, the one time they see a friend. Insurance company will say, oh, we saw you going out with friends. You must be doing that all the time. You must also be able to work. So be very mindful of what you do on social media. The unfortunate truth is that when people ask me my advice, I say the best advice is to stay off it completely, or post like the insurance company is watching. Like, assume they have an account and they're looking at it. I don't care if you only have 4 friends. I don't care if it's supposedly private. I do not trust them to follow the law. I do not trust them to not use investigators who can break that barrier or somehow get into private information. So be very careful with social media. So if you have a long-term or short-term disability claim and you are denied, there's a few steps you should take. One is request a copy of your claim file. Use the word claim file. It is all of the documents that the insurance company has generated, and during the course of your claim, all of the information will be in there, including their behind-the-scenes reports, which explain why they denied you. And that's often very useful for you to use to appeal the denial, or to have to show to a lawyer like me if you want to hire a lawyer like me to help with the appeal. So if you are denied LTD, there will be a denial letter there'll be a deadline in the denial letter to appeal. Do not miss that deadline. It is a very important deadline. The law is so awful that if you miss that deadline, you technically could be foreclosed from bringing your lawsuit to court ever. So you could lose your right to litigate the lawsuit. It's another one horrible thing about ERISA. If you're running out of time, you can ask them for more time in writing. You can just say, hey, I'd like more time for this. Or what I recommend is submit something saying, hi, this is my appeal. It is submitted. Please don't review it yet, because I still have more information to submit. And they're usually, for whatever reason, okay to do that. So yeah, this is my mini plug, but really it's for anybody in this situation, and really any situation. If you are denied, consider a free consultation with a long-term disability lawyer. I really have never heard of any situation where you should pay any lawyer ever for a consultation. If a lawyer knows what they're doing and they're worth their salt and they actually are not in it to just rack up time, almost any lawyer will give you a free consultation. That's definitely the rule with long-term disability lawyers. Pretty much every single one I know will give consultations to anyone who has them. I operate in Washington, but so you know that it's not purely a business plug. There's another great lawyer in Washington named Jeremy Bordelon. And if we litigated cases with him in Washington before, and so if you ever need a lawyer and you ever call me and you're in Washington, I'll tell you to call him too. Because just like doctors, everyone should get multiple opinions, and he's a great one. So, yeah, and as I said, there are many great ones throughout the West Coast. And another kind of quirk to pay attention to, sometimes you could file the lawsuit where your employer is located. Sometimes that can be beneficial if your employer is located somewhere fun like California, where the judges might be better, or you might have access to a California lawyer. Some of the Northern California courts are considered the best in the country as far as claimants' rights and consumers' rights, so we like to file there. So if you are in a position where if you're still working and considering filing a disability claim, one piece of advice I have, if possible, which I know isn't always, try the accommodations process. Ask your employer for accommodations if there are reasonable accommodations you think you could use, even if you expect your employer to say no. If your employer says no, that supports your Social Security and long-term disability claims, because it's basically your employer saying we can't accommodate this person with his or her impairments. Thus, it should support your ability not to work. The other thing it does is preempt the insurance company argument, them potentially saying, oh, if you had just tried to ask for accommodations, you would have gotten them. And thus you could work with accommodations, and thus you're not disabled. So asking for accommodations can help that process, even if you don't expect them to say yes. And if you ask for them and they say yes, there's nothing stopping you from trying them for a little while, and you are the one who decides if they're not good enough, right? I mean, your employer may decide, well, that it's not working out, but if you still don't feel like you can keep up despite the accommodations, that also supports your disability claim, because you can tell them you tried. Like, you tried accommodations, you tried your best, and even with accommodations, you weren't able to work. So for both of those reasons, trying the accommodation process is no risk and only upside. But then again, if you know that your issues cannot be accommodated, don't try it just to torture yourself, right? There's lots of mental health issues that just cannot be accommodated, and lots of disabilities that can't be accommodated. So just make sure you say that clearly, and follow up with that argument. Also, before you file, make sure your therapist or psychiatrist is supportive of your claim. Your doctor support is going to be probably the biggest factor as to whether the claim is approved or denied. Without the support of a psychiatrist or therapist, the claim is likely going to be denied. It's great to get support from both. If you have a therapist and psychiatrist, it is great to get support from both. If you can only get support from one, try to get support from your psychiatrist. No slight to therapists, they're life-saving, but it's an easy way for the insurance company to say, well, you're only supported by a therapist, not by a medical doctor. You can guarantee they'll pull a psychiatrist from their bullpen and say, well, I'm a psychiatrist and I say this person can't work. And no matter how good your therapist's notes or evidence is, they'll just dismiss it. If you have your therapist and your psychiatrist, you've got both cases covered. One sec, sorry. I'll mute myself for my daughter's knocking at the door trying to get in. Sorry, one second. So the other thing, make sure you are telling your therapist and psychiatrist everything. Do not be a superhero or downplay your concerns. Um, I know this is a very in-your-face thing to say about your relationship with your mental health provider. I have a mental health provider. I, have a very, I have my own relationship with my mental health provider. I don't mean to be arrogant in telling you how to communicate with them or what you need to say. I just mean to say that the insurance company is going to be the one reviewing these records line by line. And I know how hard it is to be totally open about all of your struggles, especially when you're at your worst. But sometimes, often, the things you are most afraid to share are the things that are going to support the claim the most. So make sure you have a therapist or psychiatrist that you trust, that you don't think, as soon as you say something scary, they're going to run and report you or something like that. I know that most therapists and psychiatrists establish a relationship that people don't really have that fear. But make sure you're seeing someone who you feel comfortable with, that understands your issues, that you can tell everything to, and make sure you're detailed with how it impacts you. There are people often tell me that they don't want to mention too many small things, but the small things paint a really big picture, both for your treatment and for a disability claim. So really, there really is nothing too small. And also, as I kind of said before, it's great to find a therapist or psychiatrist who is willing to communicate in writing somehow, or via voicemail or via voice outside of sessions. I know they often draw boundaries about not just hitting them up randomly, but sometimes there are some doctors who will agree to read and communicate via email within a pay structure or within respected boundaries. So make sure you're honest. And if you really feel, and this is not medical advice, this is purely from a disability claim perspective. If you feel like you're with a therapist or psychiatrist who you don't feel like you can tell everything to, that's usually a red flag. Not as much as a red flag. It's going to be hard to get them to support the claim. It's going to be hard for you to tell them everything and get the support you need. So if someone ever asks me, when they sometimes do, should I find another provider because I don't fully trust mine, my answer is always yes, if you can. Of course, if it was so easy, if only good providers grew on trees around the corner. I know they're not always easy to find, but it can often be the difference between a claim being paid and not paid. Okay, so that's my summary. Before I get really quick into Joel's law, because I'm going to transition pretty hard. The other only other one thing I want to quickly talk about is workers' compensation, and I don't have slides about it because I don't want to talk about it too much. But just to elaborate on what I said before, workers' compensation is a system that provides you for injury from your employer if you are injured on the job. This doesn't always mean a traumatic event on the job. It can mean cumulative injury. Often cumulative injury is used to describe physical injury. It can also be cumulative injury from a stressful or hostile work environment. It can also be a cumulative injury from what you're exposed to at work if your work is traumatic or dangerous. It is nearly impossible for me to tell you what your individual situation would be when it does justify a workers' comp claim or not. But if your workers' comp claim if your disability is in any way work related, again, there's no harm in talking to a workers' comp lawyer and seeing what they have to say. One thing also to keep in mind is that when you're dealing with disability insurance, they're asking if you are disabled from your job at any employer, not just your job with your current employer. So if you have a hostile work environment and you say, I can't go back to my employer, but I can work at any other employer, you don't qualify for disability insurance benefits. You have to be disabled from doing your job anywhere, not just at your employer. If your mental health is so bad because of a hostile work environment and you only cannot work at one place, you definitely do have a workers' comp claim if your work environment is that bad and impacted your mental health that severely. So if again, I'm gonna pause for questions at the end. If anyone has questions about long-term disability or Social Security disability, you can either pop it in the chat or just ask the questions after. Either are fine with me. So Joel's law. So Joel's law is a law that allows family, guardians, or conservators to petition for involuntary treatment if they believe someone needs it to protect themselves, the safety of others, substantial property damage, or any other risk to public safety or well-being. So basically, any reason you could realistically justify that someone may need involuntary treatment. This law was originally created recently, so it applies when a designated crisis responder, which is a special department in Washington that manages, they're basically the gatekeepers between involuntary treatment and the public. If you believe someone is in need of involuntary treatment, your first step is to call a designated crisis responder. Anybody can call a designated crisis responder. You all may know about this more than I do. Teacher, friend, random stranger, you do not have to be a family member to ask for a designated crisis responder, a DCR. If you ask for one for someone and they come out and they either refuse to detain the person, so the DCR would come out and then decide this person does not need treatment or detainment, or they don't do anything within 2 days. So those are the two triggers, either the DCR deciding, no, I don't want to detain this person, or the DCR doing nothing within 2 days. You have if you are a family guardian or conservator, you have the right to file a petition under Joel's law. The petition must be filed within 10 days of the DCR decision to not do anything or failure to show up. So you've got 10 days from the end of the 48 hours or 10 days from the decision. Filing the petition is done via your local county courthouse. Apparently, it varies between courthouses. Some of them you can do it online. A lot of them you cannot, and you have to physically go into the courthouse because it requires you attest to the honesty of the document. So even if you could start it online, you have to go into the courthouse to finish it. So who is able to file a Joel's Law petition and what is required? So technically, if you are a spouse, domestic partner, child or stepchild, parent, step-parent, grandparent, sibling, guardian, or conservator, you are eligible to file a petition under these circumstances. The subject of the petition must be 13 years or older. Joel's Law does not apply to anybody 12 years or younger. In order to file the petition, you need to file the court form and submit a sworn declaration. Sworn declarations are submitted under the penalty of perjury, which in most places can get you 10 years if you lie. So the court takes that very seriously. The declaration must describe a history of recent risky behaviors, similar conduct, past commitments, and or prior incompetency or insanity findings. So basically, the declaration should have as much relevant information about why this person needs to be committed as you can possibly conjure up. The declaration, your declaration is obviously limited to yourself. You should focus on threats to harms to oneself, others, property, or a high risk of criminal conduct or other societal harm which would result from not being detained. Additional declarations are allowed. People outside of just the family members are allowed to file declarations in support of the case. So if there was police reports involved, if there were teachers involved, if there are hospital reports, any of that can also be submitted, and you can ask any of those people to also submit declarations on your behalf. If you want to submit documents, usually what you do is submit. You can just attach your documents to your declaration and swear that they're legit. It's not good enough for evidence in court, but it's good enough for a judge in these purposes because they can just verify it if they need to. So definitely consider having additional declarations supporting your petition. So once you file a petition, what happens next? So incredibly, once the petition is filed, a judge will review it within 1 day. This is by far the only time I've ever seen a court do pretty much anything within 1 day. It's a really unique facet of the law. What they'll do within that 1 day is ask whether the petition provides sufficient info to justify detainment. That question does not involve a lawyer. So basically, the judge makes his decision based on the paperwork. The person isn't informed. They don't have a lawyer. And if the petition is denied, it's just dismissed. The person's never informed. Nothing else happens. Everyone just moves on with their lives. If the petition is sufficient, what happens there is the judge then notifies the DCR agency, and gives them a chance to respond to their failure to do whatever they're supposed to do. Technically, the DCR is supposed to defend their decision. So you'd expect them to oppose the petition, but upon my research, they don't always defend the petition. Sometimes they'll look back and say, okay, actually we agree with this. We probably should have detained that person, or we only didn't show up because we didn't have people around. So notifying the DCR actually might make the process better. It's not necessarily just a a government agency getting in your way. The judge may issue a detention, may only issue a detention order after another proceeding. So if the judge says, okay, this is sufficient, the judge will notify DCR and then tell the person subject to the petition that they're being considered for involuntary petition, give them a lawyer, and then within 5 days have another hearing. So no one can get committed without a lawyer, which as a lawyer is very important to me. I think it's a really important part of the law. And if you can't afford a lawyer, one will be given to you just like if you were a criminal defendant. The legal standard is less than the normal legal standard. So normally in criminal cases, if any court is going to detain you or put you in jail, they have to do the good old fashioned beyond a reasonable doubt standard, right? That we all know from criminal law. They have to be convinced beyond a reasonable doubt. That's like if you were to quantify it, basically a 99% sure standard. The normal legal standard for civil actions is a preponderance of the evidence, which basically there's more evidence one direction than another, which basically you could quantify it as 51% in one direction or another. The legal standard here is just probable cause. So probable cause basically just means the court thinks there's enough evidence to justify the detainment. Some could call that the same thing as preponderance of the evidence, but it really isn't. It really gives the judge a little bit more discretion to decide that the person is a threat to themselves or others. Now, this could be, depending on political perspectives, we'll ignore this could be a good thing or a bad thing. For the purpose of getting the petition approved, it's important to know the judge. If you have the ability to know, and I don't know how this will work in each individual courthouse, if you find the judge that you're in front of, do your best to either ask a lawyer to or do it yourself to try to look up the judge's past decisions on Joel's law petitions. I looked up statistics to see whether there are any, and there are not yet. Basically, there's no statistics out there on how many of these petitions are approved, no statistics on what judges approve them, no statistics basically on anything yet. But as it always goes with the law, the best way to know what a judge is going to do if they're making a decision is to see what they've done in the past. So in different courthouses, you may have access to prior judicial decisions. Local lawyers, and this is a role I definitely cannot fill, local lawyers who have experience in your local county courthouse will have the most experience with the local judges. They will be the ones to know whether you'll most likely to fail or succeed in a petition. They'll be the ones to know what might be the most sympathetic for a particular judge. If you ever need to find a local lawyer who has experience in your county courthouse, I recommend calling your county bar association referral hotline. Every county bar has one. Every county has a bar association. Every county bar association has a referral hotline. And if your county doesn't have one or they can't give you numbers, call the Washington State Bar referral hotline. They'll have one too. So what happens if the petition is approved? The judge may order the person be detained. Initial detention may last only for up to 120 hours. The clock stops for weekends and holidays, so it's really judicial days. After the 120 hours lapses, the person must be released. The person must agree to voluntary treatment, or the facility may petition for a 14-day voluntary treatment. This petition is done under the same legal standard as the initial petition, which is a probable cause standard. So frankly, if it goes back to the same judge, there's a good chance it'll get approved again unless something has changed drastically. If the 14 days is up, then the facility then, if they want to keep that person for longer than 14 days, they can petition for a 90-day stay. And then after that, they can petition for another 180-day stay after that time. If you ask for 90 days or 180 days, the standard changes to someone having to be a highly probable risk to themselves and others. And this was by far, as a legal nerd, the most interesting part of my research here, because it's a totally different legal standard, which falls in between the 51%, which I described, which is preponderance of the evidence, and the beyond a reasonable doubt standard, which is the 99% standard. It's kind of like a 75% standard. You have to not only show that the person probably should be detained, you have to go above and beyond and show, I'd say there's an overwhelming amount of evidence that need to be detained. So there's a higher standard for the 90 and 180 detentions. And that person definitely represented by counsel. And usually you expect that the facility and or the family members would be the ones petitioning for further stays in those situations and potentially paying the legal fees as a result. The legal fees for filing petitions are either low or non-existent. They should be administrative based on the courthouse. You may have to pay some small fees, but there's not a lot involved in it besides that. And that is the summation of disability benefits and Joel's Law. So thank you all for listening. And if you had tons of questions that you held on to, I really appreciate that. If you didn't, then thank you for your patience anyways. So here's our contact information. Our website is up here. The email is intake@kantorlaw.net. My intake team manages my life, so they'll keep everything organized. Here are social medias. I'm on Reddit. I have been on Reddit for a long time. I always answer questions. And if you happen to be on there and feel like shooting me a message or asking me any questions, you are more than welcome to do so. And that is it. If anyone has questions, oh, those are claps. Oh, thank you. I thought those were hands raised. No, there's a little claps up there. That's nice. Yeah. I appreciate the new Zoom generation that you can clap via emoji. That's good. That's great. So Becca, I don't know how you would want to do questions.
So yeah, so at this time we're gonna stop the recording.